afternoon, everyone. I hope you enjoyed your lunch and are all awake for this second part of the conference with a really interesting introduction from the Deputy Chair of the EDPB, explaining already that you will very soon find, not under the Christmas tree, but under the carnival tree, maybe if you have one, the opinion of the EDPB and the EDPS, which is a joint opinion on the omnibus reform. Why am I mentioning that? Because we have the pleasure to discuss this omnibus reform, even if it's the strike for train today in Belgium. We're going to take this omnibus very seriously, you will see, with very excellent speakers that I will introduce. First, Victoria de Posson, Secretary General of the European Tech Alliance. Olivier Micol, Head of Unit of the Data Protection Unit of DG Just. And I want to mention that we have the pleasure to have Olivier with very soon leaving the position of Head of Unit of the Data Protection Unit in February. So it's 1 week left, actually, or 2 days left before Olivier will join another unit. So we have the pleasure to have your thoughts for maybe the last conference that you will attend in this position, Olivier. Thank you. Augustin Reina, Director General of BEUC, the European Voice of Consumer Associations. And last but not least, Sophie Stala-Bourdillon, co-director of the Privacy Hub at VEB. That being said, I want to set a little bit the scene. I think it's not a surprise to you that we're going to discuss the omnibus today. I want to make sure that everybody's aware of what is the omnibus. And for those who never heard about the omnibus, can you please raise your hand? No shame. I think we can directly jump into the matter. It seems that everybody already read it at least 5 times, I guess, to know what is the surprise that the Commission wanted to reserve for this session. This session will focus on the analysis of the omnibus in 3 aspects. We want to know whether, and it was the objective announced by the Commission, you will find with the omnibus legal clarity, but also would you find simplification as announced as well, and also would you find tools for innovation in the omnibus tool. For this, we will divide this panel in 3 rounds. The first round will first address whether you find that the objective of this omnibus are achieved, or do you think that we should discuss more about simplification than deregulation, or about modernization, or what we hear you thought about it. Second round, we will just dig a little bit further into this concept. Do you think that innovation and simplification was achieved with specific tools? And in a third round of question, we would just go deeper and address specific technical questions, because we love technical questions, right? Which are sometimes at the core of this omnibus. So first question that I would love to have for Olivier, since it's a proposal from the Commission setting the scene, could you maybe expose the different understanding of simplification of the omnibus? Is it about simplification? Is it about deregulation, clarification, or is it all of the above, or a mix of them? What are the true objectives of this reform? Thank you, Olivier.
Thank you very much, Romain. And first of all, it's a pleasure to be with all of you just before leaving. But be reassured, in the Commission, we are fully interchangeable. So the other person will same bureaucrat will tell you the same thing. So don't worry about that. But to reply directly to your question, Romain, I think that clearly it is simplification, it is harmonization, it is certainly not deregulation. And we have to remind ourselves of the situation at the beginning of last year, where there was a string of intervention in member states at EU level, reports criticizing the GDPR and putting the GDPR into question, proposing to take part of the industry out of the GDPR, or small business, small operators, etc. And we had a very thorough discussion with stakeholders, civil society, business side, and we concluded, and it came as a surprise to some of the people in our dialogue, that no general reopening of the GDPR, so no deregulation. But there was a request to address a number of issues. And all what we are doing here is to address these irritants that we are going to discuss afterwards, which have been fueling this narrative anti-GDPR. We want to keep all the fundamental rights. We want to keep data protection, but we need, in order to be, and it was what the deputy chair of the EDPB said, to be very pragmatic and find solutions and address concerns. And this is not, I just want to mention it first, at the request of big tech, multinationals, etc. It is at the request of EU industry, but also in the interest of citizens in the EU, because you need implementable, harmonized legislation in the EU. So we are not touching on the core element of the GDPR. I see smiles. But we are not touching on that. We want to come with very concrete proposal to harmonize and to lower the administrative burden. So I would be happy then in your second round to go into some of these proposals, very concrete. Data breach notification was mentioned, harmonization of DPIA, information to citizens, how to clarify scientific research, something we have been waiting for 5 years. I mean, there are very concrete requests that we try to address. But I will stop here, not to take too much. Thank you very much.
Thank you, Olivier. I would just turn myself to Victoria to ask another question in the same vein. We know that industry was calling for simplification, but what do you think that should be simplified? Do you think it should be about procedures, about the substance of the law? Should it be templates? What should we simplify under the GDPR? Thank you, please.
Thank you very much, Romain. Maybe just a few words, and first thanking you for the invitation today. The European Tech Alliance represents European born and bred companies. It means that all the members that I represent are from Europe, headquartered in Europe, and have skilled in Europe. Some are present in one member state, some across the world. So just a small disclaimer. To your question, I think we very much welcome the digital omnibus and the ambition there. I would 100% agree with what Olivier just mentioned and the ambition to simplify, cut red tape. If I ask my CEOs what would help them to grow, is really we don't need to be protected. We want to be able to scale and conquer the world. And the difference between us and other tech companies is that the European market and European citizens is our first market. It's really what we care about. And we very much care about the fundamental rights, protecting citizens' data. And this is at the core of our business. That said, the digital omnibus provides some clarification. That's welcome. Provides some coherence and provides some room for harmonization. Is it perfect? No. Is there room for improvement? Certainly. Your position paper is going to be published tomorrow, so I invite you to go on the website and read it. But beyond that kind of little self-promotion, what we want to say is we need to kind of cut duplication of regime. And what you're seeing in the digital omnibus, for instance, is some overlap between the e-privacy directive and the GDPR. And we would very much support kind of the GDPR to be in lead on there. And I see that my colleagues are taking notes, so we'll discuss that further. We also very much support the data protection impact assessment. What we would like to see is not a pile of requirements here, but more a consensus and harmonized approach, because we want data to be protected, but we do not want to be taken into long reporting. We want meaningful reporting. And so happy to discuss what needs to be in it, but let's not have a 100-page reporting requirement, but something quite effective that makes sure that citizens are protected. That's very much at the core, but at the same time that European tech companies can innovate. I'm going to leave it there. Very happy to go more into the details, but for the moment, sharing the floor with my colleagues.
Thank you, Victoria. And for the sake, of course, I was just a provocative question, Olivier. I don't say that there was an attack on the core of the GDPR. It's just some voices that we heard already, and that's the core of the discussion today, actually. Question for you, Sophie. Simple one, of course. Do you think that simplification is possible without cutting the right of individuals to data protection?
Thank you very much, Romain, for having me today. So I will have to disagree just a little bit with the previous two speakers, but very quickly, and to answer the question in 3 words. I guess it depends on what we mean by simplification. If this is simplification as we live it, are living it through the digital omnibus, I think negative impact on individual rights. If this is simplification as we dream it, maybe not. If we are thinking about avoiding duplication of processes or trying to harmonize, shooting for a high level of protection, then maybe not. But if we speak about a concrete, very concrete proposal that we have on the table, then I see some negative impact.
Thank you, Sophie. I will turn myself to Augustin from the consumer perspective, because Burke is, of course, taking a consumer perspective, which doesn't really change, I guess, the discussion here. Do you think that simplification risks shifting the burden of protection from companies to individuals? That's the first question that I would have.
Simple answer, yes. And I think we have the feeling that we have read a different proposal. The one I read is a little bit less positive, I would say. Especially when we are, I believe, failing to answer the question of simplification for whom, and at the expense of whom as well. And then here, the idea of trying to make compliance easier, enforcement faster, to bring more legal certainty to companies and consumers alike, of course, that's something that everybody will support. But what we are seeing in the concrete proposal, for me, it leads to completely the opposite direction. So here, and sorry, we don't need to sugarcoat. We are reducing standards of protection for people. This is what this proposal is doing, for the sake of Europe's competitiveness, to allow scalability, so on and so forth, that we can discuss it. But the reality is that we are scaling down on protection here. We are not touching the core of the GDPR, we're not touching the core of the principle of the data subject rights, but by changing or making these very targeted changes into the definitions, the legal basis for collection and processing for certain uses, I'm sorry, we are undermining the system of protection that we have. And I think that here also we need to be honest about that. And then we need, if we want to move forward, we need to question ourselves, for whom are we doing this? It is really for the smaller companies to scale up, or there is a question of helping compliance that needs to be addressed first, or it is actually ultimately, even if that's not the intention, to facilitate the further concentration of data, but those that they already have data in Europe, and that they are not necessarily European companies.
Thank you, Augustin. And it's a perfect bridge to ask a further question to Olivier regarding the simplification and to which category of person that would benefit. Do you think that there is a red line beyond which simplification could not coexist without undermining the rights of individuals when it comes to data protection? And if there is a red line, do you think, can you just give us a hint of where this red line would be?
Yes, I mean, there was a red line, which was, let's not reduce data protection for individuals. This was the red line. So it's a very simple red line. And then I would like, I think it's very important when discussing about this omnibus, to look concretely at what we propose. I do not see why having single harmonized list on data protection impact assessment would lower the rights of the citizen. On the contrary, it's ensuring harmonization throughout the EU. Indeed, we clarify, for instance, when you have to do a data breach notification, because we know that DPA is swamped with thousands of notifications, and they have no time to go through that. So we ask them to focus on the most relevant one. It is not about lowering the rights of the citizen. When we come with an implementing act where we come with an assessment by expert on what technology could be helpful for small business when they want to pseudonymize data. This is not the Commission deciding on definition of personal data. These are concrete examples, support to help a small business to properly pseudonymize data. This is not lowering the rights of the protection of the citizen. So I think we have to see that a legislation which is more understandable, which is more harmonized, where the enforcers have clarity on how to apply it, because if we take the example of personal data, you have different interpretations. We talked this morning about the relative absolute interpretation, but we have some DPA implementing the relative approach. You have some implementing a different approach. So what we want is to have a harmonized and, let's say, consistent enforcement by stakeholders who understand the law. This is what we want to do. Thank you very much.
Thank you, Olivier. And I would just, of course, maybe ask if the other panelists want to react on the question. You're also free to. This is a safe space, of course. So you're, and you can also react on the question if you. And I hear disagreement, so I'm really happy because I think a panel when everybody is agreeing is kind of not interesting. If you want to,
I can jump in on that as well. Of course, the examples that you gave, are aimed at easing compliance. And again, we are not against facilitating compliance. We are the first one to say that compliance should be easier, that there should be dedicated, points of contact for SMEs to get all the assistance that they need to be able to understand better the legislation, so on and so forth. But when we start tweaking definitions by adding, at the end of the day, new lines of defense for companies. How you define what is immediately identifiable. So, I'm sorry, but this adds new layers of defense for firms to say, look, if a data subject complains or goes to a DPA, well, I have something else to put as a barrier to justify my illegal practices. And I don't think that helps consumers. I don't think that helps companies either, because that adds a new layer in the legislation that makes it even more vague to identify what is considered personal data or not. It's based on one specific judgment, but there are many other judgments as well that have shed light on this question. So this is the type of points that, even if it's a very small intervention, it undermines the system on which it is built up. And we cannot underestimate, the importance of definitions, because that is the starting point for a regulator, for an enforcement authority to act. The same with the legal basis. If you're shifting consent to legitimate interest, that basically you're taking control out of people. So that is when we find that there the simplification exercise falls short into ensuring that consumers are duly protected.
Victoria, you want to add something?
Yeah.
I see.
Maybe to illustrate one of the points of where the digital omnibus is very much welcome from the industry perspective is, yes, clarification on some definitions, because what is personal data? We had a panel this morning about it, but it is an existential problem that companies are not able to very easily decide this is personal data or this is not. I am quite surprised to see that this should be very clear to companies. If we want European tech to be successful, if we want us to be able to scale, we need consumers to be protected 100%, and I'm not going to disagree with Augustine there. But we need companies to have a clear understanding. This should not be a discussion for a panel. It should be black and white. Is it black and white today? No. Do we need clarification? Yes. Is the digital omnibus for that welcome? Yes. And that's very basic to understand. I'm very sorry, maybe there's a lot of data protection lawyers in the room, but my companies do not want to pay data protection lawyers to have a clarification on that. They want to be able to make progress very easily and say, okay, it's data protection, I need to treat it under GDPR. It's not, this is how I can use the data. And this is how data is today super important for us to be able to scale, but we need to also protect it in some circumstances. The GDPR provides 4 legal bases. Consent is one of them, and when it's consent needed, let's use it. But also having legitimate interest, that also is useful for us to provide some clarification on that. Same for pseudonymization. Having a single entry point for breach of data is very useful. having a single list for data protection impact assessment is very useful. These are all elements that will not harm consumer protection and data protection for users. So that's quite important. Maybe one point where I will disagree with Augustin is the centralized consent mechanism. We understand the Commission's objective here to make it easier for the consumer, but at the same time, one, it doesn't really respect from us the GDPR perspective that it's not specific, informed, freely given, and unambiguous. So here we see a clash. But main problem is this will create a new gatekeeper. And this is exactly clashing with the DMA objective. So creating a centralized mechanism here, for us, it doesn't work with GDPR, plus it doesn't work with DMA, plus it limits access to data and push to the centralized centralized data ownership, which is really not great. So there I'll 100% agree with Augustin.
Thank you, Victoria. I think you want to add
something. I wanted to add something. And here I'm going to put my industry hat. Because before going to the Brussels Privacy Hub, I spent some time in industry, and I think I got some learning there that might be useful for the discussion. And so beyond deregulation, I would like also to put on the table maybe the concept of cognitive disorientation, maybe. And this is just here to show empathy to the Commission. There are things that we know already. Having the expectation that everything is going to be set very clearly in the black letter of the law might not be exactly the right expectation to have in this domain. What we know, though, I mean, this is a debate that dates back more than 10 years ago. Lots of work has been done around 2014, 16 in this space. And looking at the identification practices, there are very important learning that emerged. The first one is when you are trying to process data to reduce re-identification risk, there is one key question that you need to be asking. Are you going to release the data in an open environment or in a closed environment? If you release the data in an open environment, you want to know what the best practice is in this, but it's going to be very hard to claim that pseudonymized data in the sense of masking direct identifiers could amount to anonymized data. This we know. Second, if you release the data in a closed environment, simply treating the data, again, we know this is not going to be enough. If you want to make a reasonable claim that maybe this could be deemed anonymized, you will need to have controlling the environment. You will need to know what the purpose is. So again, this we already knew. And to some extent, that was there to drive the practice. You can look around and see, look at, for example, the work that the ICO had been doing in this space. This was already emerging. So it was not like we were swimming in a pond where we could not see anything. And what is also very exciting, actually, is to see that DPAs have been working very hard. Here I can think, for example, one example is the CNIL. Of course, I am a bit biased here, but they have understood that they need to be doing something. The quality of the guidance that we've seen in the last few months is actually, I would say, very high, even if we might not agree with everything. So, yeah, there are good signs there. We understand that it's a layered system. You have the principle, and then more is going to come through guidance. I'm not sure the industry was completely lost. And just to finish on one point, having worked in data science environments, the problem that I saw there was not so much a problem of over-inclusivity, but more a problem of under-inclusivity. So the people here still think in terms of PII, personal identifiable information, with a very narrow understanding of what it is. If you give them more arguments in this sense, then I'm not sure we are going in the right direction. Thank you.
Thank you, Sophie. I would like to finish the first round of questions, so I would just ask you to be brief, because newsflash, the question was shared before, so I'm sure you can be short in answering the question. Victoria, I think you already answered the question. Do you think that this omnibus reform is bringing legal clarity, which is one of the objectives of the omnibus? But I think you already answered this question 5 minutes ago.
My answer is going to be briefed. It's a step in the right direction. Is it perfect? No, but it's a step in the right direction.
Thank you. And I would just ask a question to Sophie, which is a little bit the topic of this round. Do you think that this omnibus is simplification, clarification, deregulation, something else, or all of the above? And I will ask the question to the audience as well after this first round to know what is the take of the audience here.
So in the main, I mean, this is how I understood actually the first question. So in the main, I see it more as being deregulation. Has been announced also through public announcements. It's not necessarily a new thing. Not much clarification, some more confusion. Some simplification. I would agree with DPA. It's good to have one template, but this, in the main, I'm not entirely sure this is really enhancing what we had already. And I'm going to add an additional word here. I'd like to warn again paper law fetishism. This habit to keep and waste all your resources on tweaking and reworking the statutes to solve all our problems. I'm not entirely sure this is the way to go. At the Hub, what we try to do is try to then forget just a little bit about the statutes and try to talk to the builders and see what they say. And in particular, the builders are interested in developing a model that is not necessarily the model of the big walled gardens. They believe in an alternative model. And the feedback that we got there was, please, can you just enforce the framework and then we'll see where we are. We believe strongly that it's a good thing to sell trustworthy services. And how do you show that you are trustworthy is by showing that you are compliant. But we need more visibility. So yeah, in a world where resources are limited, I think it's also important to look on the ground to start with.
Thank you, Sophie. And the last question for you, Augustin. Do you think that we can regulate complex situations like the advertising industry, the ad tech industry, international transfer, AI data training with simpler rules? And do you think it's feasible to have this level of simplification, which is give a leeway, maybe for the EDPB or for Data Protection Authority, to further complement guidance to make it possible in practice?
So it's a little bit of a fallacy. They are not simple rules. They're not simple rules because legal systems are complex, because human and market interactions are complex. And there's nothing wrong with that. But complexity is not the enemy of predictability or certainty. So it's normal to have a complex regime, especially when, and we have been discussing also this yesterday, with different legal orders, interact with each other horizontally across sectors, but also vertically, EU, national, so on and so forth. So we should not just try to simplify the entire legal order because we're going to fail. The markets are complex in itself. But what we certainly can do is to ease the compliance by those things by creating legal certainty and predictability. The work, for example, of the EDPB with their guidelines is extremely important because you have then the regulators coming up and saying, look, in this type of situation, this is how we will interpret the law. And that's already a very important tool for a company in order to get that predictability. But by just simply simplifying and cutting down the rules, we're not going to get the objective of creating that certainty. Because as soon as you get rid of the legal framework, then it's contract that comes into play. And contract becomes even more complex because you have those that are in a strong market position that are going to impose over the others, being the consumers or being SMEs, so on and so forth. So the legislation there plays an extremely important balancing role vis-a-vis these interactions between companies, between themselves, but also vis-a-vis consumers and citizens are the weakened part of the relationship. What I think is, however, really important, and I think the EDPB is certainly in the good track, is to take ownership. You need to take ownership over your GDPR. You need to take ownership over creating that legal certainty vis-a-vis firms and vis-a-vis consumers. But that's what I will not overly focused on simplifying, but actually creating predictability.
Thank you, Augustine. And do you want to add something, Victoria? No. Yes, no? Okay, sorry. Olivier.
No, sorry. No, just to clarify a few things, because here the discussion could be interpreted as, okay, we are taking away rights, we are deregulating, etc. This is not at all the elements of the debates or the justification of the proposal. We are not reducing rights. This is not the objective. We are not taking any rights away. What we want is to have an harmonization. What we want is to have a clarification. And many of the issue we discussed, data protection, impact assessment, that it is harmonized, I don't see where is a problem. About the rights of consumers when they are in face-to-face in a small shop, etc. I don't see where the problem lies. About we are not creating legal basis, for instance. Just to be clear on that, when we talk about the training of AI, what we are saying is that in line with the opinion of the European Data Protection Board, we say you can use the legitimate interest as a legal basis when you fulfill all requirements. And we add and we detailed what should be in this balancing test there. And Augustine, I fully agree with you that we should not push things to the individual. And when you use consent, and a lot of people think consent is a most protective legal basis. No, because precisely you push that to the individual, and the individual, we know, consent. You have all this famous experiment when you put in the contract, I would give my first newborn child to the devil, and everybody consent, basically. 99% of the people consent to that. When you use legitimate interest, it stays with the controller. And in the case of AI, we are, again, basing ourselves on what the EDPB, in its wisdom, said in its opinion. So we are not creating new legal basis. And indeed, there was a reference made to the very important EDPB guidelines, and we know the deputy chair mentioned it in her speech before. There is indeed this Helsinki statement to make the guideline more actionable, shorter, more understandable, and we very much support this approach from the EDPB, but there are some elements that we can clarify already in the legislation itself. And this is what we are trying to do. Thank you very much.
Julia, last word, because I would like to go for the round two.
I'll be quite quick. I think you heard the UTA call a lot for enforcement. On GDPR, enforcement will not be enough because there are different interpretations. So we need better enforcement, and that's through more consistency, more clarification, so that there are less divergence between the member states. So enforcement is a first step, but we need smarter, better enforcement through more harmonized or consistent interpretation of the GDPR concept, and that's what the Digital Omnibus bring. And then to Augustine's point on dialogue, 100% agree with you, but as companies, I can tell you that we are going to see data protection authorities or national enforcing authorities. We ask for clarification, we try to do a good job, and the resources are not there, and we don't blame them. It's quite difficult on our side too. But the problem is when you try to have clarifications, you don't get an answer. You do the best you can to implement the law, and then after that, you get a fine or you're being challenged on what you've tried to develop over the years. It is problematic, and that's the reality on the ground. So we need a better dialogue. We need more standards, and for instance, that's hopefully what the Digital Omnibus will provide.
Want to answer to that, Augustine? Very shortly, if I may, because we
Very shortly. I can understand and I sympathize, with the companies that are trying to develop something and they're trying to contact a DPA and they don't get any answer. But that's not because of the law. It's because of the system not serving the companies as it should, perhaps. So it's a question of resources, a question of implementation, so on and so forth. But it's again not a problem in the law itself.
Thank you. And as a privilege of a moderator, I will also add my 2 cents. I think but I think the question is already tweaked. Is the GDPR the only law when there is a problem of harmonization of the EU law? not so sure, because I'm here with the law for the GDPR, but it's not the same for other laws. It just needs harmonization, and it's not the Court of Justice here to ensure consistency. Do you have bodies like the DPB in other areas of law ensuring consistency? Not always. So I think compared to other laws, maybe the GDPR is in a better position because we have a body ensuring consistency of interpretation, and in some other areas of law you don't have that. And second, it's also a nice privilege that I think that controllers can go to the PAs to ask the question regarding compliance with the GDPR. If I go to my tax authority in Belgium, they will probably just push me away because they don't want to answer my legal questions for free. So again, is it in other areas of law that you can go freely, I mean freely and for free, to a regulator to have an answer? That's just questions that I wanted to ask. Before going to round two, I would like to ask the audience just a quick question to wake you up after the lunch. Who thinks in the audience that this omnibus is about simplification? Seems that Commission still need to convince a lot of people. Who thinks that it's about legal certainty, it's bringing more legal certainty?
Well, maybe the question is not is it about, but is it achieving?
Oh, is it achieving? You can achieve several objectives at the same time. Who thinks in the audience that this omnibus is achieving, sorry, I just forgot, simplification, did I say that? No. Simplification, legal certainty, and is this omnibus bringing also some added value for innovation? And who thinks that this omnibus is about deregulation? I think we have a majority for the last answer, and maybe all of the above, but I guess we don't have time to address all these things. Just to see whether our panelists convince the audience. I will just switch to round two, and I will ask you to be also as short as possible, but we will have time for Q&A, don't worry, we have 15 minutes of Q&A, and I will ask my colleague to ping me if I'm going beyond the time limit. First question for the round two is just to discuss this interplay between the right, the innovation, and the simplification. My first question to Sophie would be, basically, do you see any fundamental problematic topic in the omnibus regulation, the proposal regarding the right of individuals?
There are a couple. So again, I'm going to go back to the domain. So Olivier was trying to say they want to keep the rights, but by changing the scope, you obviously impact the rights. If data is not considered to be personal data, then there is no right. So that's the first thing. And here, again, it's important to understand how practice is built and how you think about compliance on the ground. So if there are signals that are being given that now certainty increases, or there are more arguments in favor of not finding personal data in the personal data that you're processing, then of course that will impact practice, and then also at the end individuals. So that would be the first one. And the second one, so some of the rights are being slightly tweaked and made more conditional. Think about the right to access, which has interdependencies with other data access regimes. In some way, you would need some justification now to exercise the rights, which is problematic. To me, yes, making rights conditional and then working and trying to redefine the scope of the law is the two most important impact.
We would consider sort of red line, I guess. Victoria, I wanted to ask you, because we're talking about innovation, do you think that this proposal is bringing advantage to, or is it beneficial for EU businesses?
What will help businesses is clarification. Is like, if I have to look at the figures from my companies and you ask CEOs, 30% of their resources, workforce, employees, is put on compliance. So instead of having an engineer working on making a product better and challenging American, Latin America, Asian companies, it's putting on compliance. This needs to stop. The problem today is the cost of compliance. Compliance will always have a cost, but it's disproportionate. 30% of workforce. It's way too much. So what will help is bringing clarity, making sure that we understand regulation, having improved dialogue with authorities so that we can comply at an easy and cheap cost. The EDPB is a great tool, but you can also take long months, if not years, to make guidelines. And we don't have years to comply. So that's also one of the challenges. So if I have to go back, we would very much welcome a Digital Clearhouse 2.0 because data, it's not only in data protection, data comes in every sector. And we need to have authorities working more together because we are sometimes stuck between data protection authorities and consumer protection authorities, just to illustrate, or data protection and competition authorities. And we, as company, we just want to comply. We just wanted to make it easy and wanted to make sure that the fundamental rights are respected. Back, our consumers are central. European consumer is our first consumers. Europe is our first market. So for us, the fundamental rights are essential. But we just want to have clarity on how to comply. And the Digital Omnibus tries to provide that. Is it perfect? No, and we have an 11-page document that will explain how we believe it can be improved. And very happy to discuss that. But it's a step in the right direction, and I think we need to make sure that European companies do not spend 30% of its resources in engineers, spending time on understanding what Brussels lawmakers have trying to do. Thanks.
Thank you, Victoria. And I have a question as well for Augustin. How do you assess this proposal against the promises of competitiveness and innovation that was already announced? And it was one of the objectives of the Commission. Do you think it's going to help? Do you think it's going to be prevent? Do you think it's not going to change anything?
Look, I think this proposal is a little bit of a bricolage. I don't want to say that there is nothing of simplification, there is nothing of the rule. There's a little bit of everything, and it's a little bit of a mess. Also because of the process in which led to the adoption. I would have loved to have this proper discussion in the context of a proper evaluation and assessment of the GDPR itself, in light with all the elements, including the enforcement and implementation. But we are where we are. Now, the fact that we don't have scalability in Europe in this context of digital firms cannot be attributed, certainly not solely, but I would say cannot be attributed to the GDPR. It's much more complex. This has to do also with the fact that we have a lot of fragmentation across member states on implementations of many laws, not only the GDPR. I think that we could be really happy and we should acknowledge that we have a regulation. So normally, it's applicable across the member states with its faults in this enforcement, but it still is a regulation. While it's still in other areas, we still have different levels of or different standards across member states, different requirements for companies, so on and so forth. So I think we need to take a more, I know it's a little bit of a cliche say, but more holistic approach, or look a bit broader. Also, how do we attract investments in Europe? We're not going to attract investment by changing the definition of data protection, I'm sorry. We're going to attract investment when you properly build a capital markets union, which is interesting for companies to go and get listed in Europe instead of New York. So it is much more complex than that. And of course, data protection, or this regulatory framework, can play a role. And again, for me, the contribution should be in making easier to comply, creating tools for the companies to get, simple access points when they have questions. Now, who should pay for that? I don't know, but certainly not the consumer. But I mean, it should be made much easier. And the same with the enforcement. I'm sorry, how long we have been discussing enforcement on data protection law? How long? And still we not get there. So I think there is a question of institutional design that needs to be revisited. We just got the cross-border enforcement rules adopted. Let's see how this is going to play out. But still, I hope that in 10 years we're not continuing having exactly the same discussion, and we can actually, move on also in the field of enforcement of the GDPR.
Can I just do one thing about also maybe to share the pain here? Maybe there is something also in the compliance culture that is not exactly working very well. And as lawyers and compliance folks, maybe we have some share of responsibility when we try to very often focus on the complexity, too much complexity, and are not very able to then support decision making. So I think, This is probably not necessarily helping the industry in this case. But again, this is different from saying that GDPR is complex.
Olivier, you want to add something?
Yeah, just one point as well, because I mean, of course, you can always interpret the intention of somebody else, and we all have our own filter, and etc. But just at the risk of sounding repetitive, but I am a bureaucrat, the next one will be the same. It is not the objective to deregulate. I mean, if we wanted to deregulate, we would have put, a full-fledged reflection on the GDPR, and we would have had engaged into a process as some actors who are against data protection were advocating. Let's have a thorough reopening of GDPR. And then it's a guarantee for a full-fledged discussion on the rule, lowering of the risk of data subject. But as I said at the very beginning, when we were talking, and it's not, one meeting, two meetings, it's 10 years of implementation, 10 years of discussion with stakeholders, civil society, business, academics, etc. It's not two bureaucrats on whatever floor, on whatever great building, deciding, let's harmonize data protection impact assessment list. It doesn't come in the morning just like that. It's really based on very concrete discussion. So this is really what we are trying to address. I know it's not a grand statement. It's not about, I can speak for hours of fundamental rights, data protection. We have heard endless discussion on that. It was, let's look at our data protection framework. We value it all together. And there are a number of points which are problematic that are not touching on the core principle, on the value, on the principle, on the legal basis. And let's see if we can address them. And of course, the text is not perfect, and we are fully ready to discuss with the co-legislator, with the stakeholders, etc., how to address them so that we end this narrative against the GDPR being an obstacle to innovation. And we want, by the way, to keep EU industry, innovative industry in Europe. We prefer to use, to have EU actors developing AI in Europe according to our values, according to our rules, rather than having these tools being developed elsewhere. Because these are the same people who would fight and defend very strict interpretation of the GDPR, and then we are using US, Chinese tool. And this is not a problem, but we want to have this tool developed in Europe according to our standard, to our value, to our fundamental rights. And we need to ensure that our legislation allows for that. So I think we have to put the discussion straight and to make it super boring, in fact. We have to look at the proposal, we have to go through it, and very concretely, does it work? Yes, no. And we stop, having, let's say, a discussion on principle, because we all agree by this principle. We all agree by the charter. We all want to defend data protection. But we want to do it in our framework and in a manageable way. And I agree fully on enforcement. On enforcement is a key issue, the interpretation, the enforcement, which has to be consistent, and this is one of the key points. So, Augustine, fully agree with your point on that. Thank you very much.
Augustine, you want to react? I just want to jump to the third round, but
super briefly. Actually, it's not react necessarily to you, Olivier, but I would love to hear what you think, Victoria, on the question. If you go specific, and then we make easier for firms to collect data to train AI, who is going to benefit from it? For me, when I see it, Google, Meta, the big tech companies, but this is going to really create the scalability.
I think sorry, Augustine, and I'm keeping into round two, but for European tech companies, having access to data and having a clear cut on what's personal data and what's non-personal data and how to treat that data will help train AI models. If we have access to data, we can train our models, and it's based on European data, based on our values. For the moment, that is still a challenge in practice on the ground. So having that clarity through the digital omnibus is welcomed. One of the point is the categorization of data and having access to, being technical here, but having access to sensitive data. One of our proposal to change the Commission text is, for the moment, limiting access to sensitive data to train AI model could be challenging in practice, because if I have to simplify it, it means that you will mainstream it and you'll end up with white men data instead of having diversified data. And what we want in Europe is actually extremely diverse, and we should be proud of that diversity. And to be able to train our models well, we need to have that diversity taken into account in our AI models. And we want European consumer to have access to AI models trained on European data while using that data in a privacy-friendly way. To be able to do so, the digital omnibus is a first step in the right direction, and that will empower European tech to be successful. What we are seeing today is international actors, whether they're coming from China, US, or Latin America, that doesn't matter for us. But they have access to the data from other continents and apply those lessons learned in Europe, making it more successful. If I have to say concretely, what does that mean for, let's say, your daughter, Roma? When she wants to buy jeans, well, you'll see that the jeans is very much associated with that white T-shirt, and that combination works extremely well in the US, Latin America, and China. Well, that actor will propose the same combination in Europe. Well, European actors will not be able to kind of make that association because we don't have access to the same level of data and insights. I'm oversimplifying it, but that's today what we are concerned as European tech companies when we are talking about access to data. And that has nothing to do about whether how much you protect your data, yes or no. It's we want to protect the data, yes, and we want to be able to use that aggregated data and the lessons learned from that data to be successful too.
That much received. Thank you. I'm sorry that we have to jump to the third round, which is the boring round that you just suggested, Olivier, which I'm happy that you like me to be boring sometimes, because I think it's not boring, but very interesting to deep into the very specific issues of the GDPR. And I would love to, you've seen that you're trying to dig deeper into the text. And I would have the first question, which is an open question. And it's also preempting a little bit and announcing the next panel. I will maybe address this first to you, Augustin. Do you think that this proposal will actually and efficiently address the consent fatigue, especially with the new Article 88A, to be very boring and technical, proposed by the Commission? Do you think that this consent fatigue will be ended, improved, or even worse?
First, the question of the consent fatigue is not a problem of the law, it's a problem of implementation. That's what we have been saying for forever. Of course, the possibility to reject or not to give the consent, and that the fact that the companies cannot ask again for it during a period of time, that's I would say, step in the good direction. You know, that helps to address this problem. But fundamentally, the starting point is that this consent fatigue has been, so to say, imposed by a poor implementation of the law. What we have to see, of course, is how different regimes will come into play. And I think that is a fair point on avoiding duplications. At the same time, here we are talking about two different fundamental rights, data protection and right to privacy. And in that regard, I think looking at the interaction between these two is fundamental. But as I said, we will need to look more more concretely how this will be rolled out. Although what we have been already saying is that if someone is going to put a cookie to collect personal data, consumers have the right to know about that. They have the right to say no as well about that. But the design, unfortunately, has not been optimal in the way that it has been implemented so far. So we hope that with this, at least things might be able to improve a bit.
Thank you. Maybe I invite you to, if you want to react quickly, because I have a lot of questions for the boring part. So you're happy to have your views, of course. Otherwise, we can skip.
No, very quickly. I would warn against weakening the principle of confidentiality of communications as as a principle, which should apply irrespective of the categorization and nature status of the data. I think that's important in a society where every communication is mediated. And then, yes, there is room for improvement here. We need legal backing for some of the standards, but I'm not sure the quality of the drafting is just there.
Victoria?
I'm going to go on the consent fatigue. The problem here is how many times you've been asked to provide your data and the length of those data disclaimer. If you've connected to the Wi-Fi in this room, you had to consent. Who read that? Like a very long paper, we all scrolled down and went to accept it. I did it myself, no blame, but the question here is really how often and the length. And if you ask how much information you need to put there, if you ask the data protection authorities or the consumer protection authorities, you get very different answers. So from the companies, we are in between, and I said we try to comply. So what do we do? Should I listen to the consumer or to the data protection authority? So I've defended the digital omnibus. Sorry, Olivier, I'm not going to go with you on this one. But Article 88B, we really don't like it. And we would like to get it total deletion. This is what we're going to ask for it, for the simple reason that, one, it introduced new gatekeepers when it comes to data, and very concerning data centralization, so that we're definitely not in favor. First, it doesn't align with the GDPR specific and informed consent. And I agree with Constantine here, consumers have the right to be informed and have the right to say no. But for us, this kind of consent mechanics will maybe in practice make it more complicated because you ask it twice. Also, having it at browser level is a bit old school. A lot of us asking us on mobile, what if you do give different consent on browser versus mobile? So in terms of practicalities, it's difficult. So I'm trying to be positive here. The solution here would be to limit when you need to ask consent, not by limiting consent, but making more useful. And there are, in the GDPR, 4 legal bases, so sometimes consent might not be the only tool, so providing clarity on that is welcome. 2, aligning terminal equipment, so the GDPR with the e-privacy directive, and we're not yet there. And then 3, and we haven't talked about it, is privacy-enhanced technology. Pets are a solution, and we haven't talked about it. So privacy-enhanced technology is part of the solution. Now, we would like to have guidance and standards on this so that we are not relying on only 1 or 2 service providers, but that the European industry can also develop these kind of privacy-enhanced technologies. I have a few in my membership that are offering those solutions. And so this is also maybe the future. So let's look into this.
Thank you, Victoria. I would skip to, I would like to have a 2 technical question again. Maybe I would just take this one. What do you think about the new definition of an abusive request for access to your data? Do you think it was a real problem, and do you think that the reform will address it? First come, first served. Don't fight. Olivier?
I can come in on that one, but I wanted to reply to the other one, but fine. I mean, the fact that we have clarified a number of scenarios, of low-risk scenario to avoid consent, and the fact that when you refuse, you keep it for 6 months, the refusal. So I think this will drastically reduce the issue. And of course, we disagree on the browser, but this is other technology. But on the abuse, I mean, here again, just to be clear again, to avoid any, principle, high-level discussion, the right of access is in the Charter. It is in the GDPR. There is no question to put in danger the right of access. So, I mean, just being said so that we avoid having this discussion. But the idea is really to address, and we clarify in the recital the situation where it has been reported on a constant basis on the abusive, let's say, use of this right for issues which have nothing to do with data protection, which can be addressed also in sectoral legislations, etc. So we are fully aware of the Charter. We read it every morning before we start the work. We have read all the case law of the Court of Justice. We are fully aware of the interpretation of the right of access by the Court of Justice. All that we know. We are fully aware, I can assure you. And on this basis, we propose to address only this abusive scenario where we give example of the intention to do harm, etc. So thank you very much.
Well, we perceived, Olivier. Augustine, you wanted to answer. Do you think it's the right way to go?
The question is, what is the evidential basis to do these interventions? And that is, sorry, not clear. I have not seen abuses. I've certainly not seen abuses. So the question is, are we trying to fix a problem that doesn't exist? Are we trying to prevent a problem that might not exist? So what is the evidential basis to do this type of interventions? Which is, like it or not, is an intervention that interferes, with the right to access. Because at the end of the day, it is what it is, and eventually the court might have to position itself on this very specific question as well. But there is also an element of decision-making processes that, at least for me, it's not clear where that comes from.
You wanted to add something, Sophie?
No, I was going to ask Olivier if he really thought that intervention was needed. Yeah, on which ground? But yeah, that would be my immediate reaction.
Because we wanted to ask the evidence. No, nothing to add, Victoria. But I will have a time. 2 minutes to have a last question before the Q&A. And I think I would just do myself a little favor by asking my favorite question of the reform. It's not a simple one, but I would like to know what you think about this changed Article 22, which introduced changes without changing the meaning of the provision, which is leaving me a little bit surprised, because apparently the intention was to change the provision without changing the intention. Do you think that, what do you think about this change? Do you think it's going to improve? Do you think it's going to decrease rights of that subject? Do you think it's going to bring legal certainty, or the opposite, legal uncertainty? And this article is about automated decision-making, which is also quite linked with AI, as you know, so I think it's quite important to mention it. Did you have a problem here? Do you think that this reform is going to solve it? Whoever wants to answer. I know it's not a simple one. Olivier.
Okay, so I think you summarized it in a very clear and correct way. We are changing the article without changing the condition. So we have until now a prohibition with exemption, and we change it to an authorization with conditions. And the conditions are the same. So from a purely, let's say, intellectual point of view, you're not making any changes. But because it was framed as a prohibition, it was interpreted in some member states, not in all member states. In some member states as, a prohibition has to be interpreted restrictively. So at the end of the day, you have basically, in some member states, a very strict interpretation on an automated decision-making, even if, from a purely logical point of view, the conditions are the same. So this is why we turn it into a right with condition. And also, what we do, we add the wording that the mere fact that you could take this decision, you can come to this decision without, by putting 20 persons instead of an automated decision-making, then it would disqualify automatically the automated decision-making. Because otherwise you disqualify always any automated decision-making. Needless to say, the right to obtain a human intervention, etc., all that is still there. It goes without saying. Huh? But again, these two changes, the prohibition with exemption to an authorization, a possibility with condition, and the clarification that, putting 20 people instead of doing an automated decision-making does not automatically disqualify the automated decision-making. And this is very important for sectors like if you want to get a quick feedback on insurance, on creditworthiness assessment, etc., given that you have always the right to a human intervention and you have the right to contest the decision. Thank you very much.
Thank you, Olivier. Just unless someone wants to add something, we can skip to the Q&A.
Can I just ask another question? And so the principle of necessity, is this being touched by the rewording, or is it the same?
We don't touch on the condition, on the necessity and proportionality. What we are just also clarifying is that, because you have to compare between the different intrusive methods, and you have to choose the least intrusive one, but on this basis, you cannot say, if I have not, I'm not using an automated decision making, I'm using, again, 20 person assessing this creditworthiness. You cannot simply disqualify using an automated decision making because you can put human beings doing the work. This is what we want to avoid. It was not interpreted like that in most member states, but in some member states, again, and this is a fight against fragmentation, we are clarifying this aspect. And this is super important for innovative industry. Again, you have the right to human intervention, you have the right to contest, etc. But we bring indeed this clarification.
Thank you, Olivier. We will just skip directly to a question that I received from the online audience. I'm sorry, but I don't have the name of the person who just asked this. I'm trying to summarize because the question is quite long. Basically, this person is asking whether you're not afraid that every time there is a new technology like AI or biometric technologies in this instance, and it creates a new omnibus. It seems that this person thinks that the omnibus is just made for AI, but that you create a new exemption or a new legal basis or a new derogation. We are basically deviating from the technological neutrality of the GDPR. So basically, every time we have a new technology, do we have to invent a new omnibus? Or is it a problem?
A very quick reaction. It would be better to be technology neutral. GDPR was technology neutral. The omnibus refers to AI. It seems to be a bit less. It would have, at least from my perspective, just picking AI is almost everything. So if you don't try to understand why this is being used, like research and development, decision making, this is where the difference I think is important and matters, and this is how you should think about rulemaking. So I would think it's possible to be to have better drafting and less dependent upon the actual technology that is being developed on the ground.
Victoria, quickly as well.
Maybe a quick reaction. We see the digital omnibus as clarifying some of the concepts and improving the enforcement by bringing some harmonization. I don't think that's necessarily relating to a development of an AI technology. Yes, there are some mention of AI and there is the concept of AI that's involved, but that's not the core of the objective of the digital omnibus. For us, it's really improving the enforcement by bringing more harmonization or consistency among the member states. Thank you. And clarifying some of the concepts to kind of actually go back to the core principle and objective of the GDPR, which was enabling the use of data for companies and protecting consumers. Those two needs to work hand in hand.
Thank you. We'll turn to the audience, of course, to have a question. Sir, first we can ask you a question and present yourself.
Robin from FEDMA. Sorry, so a quick question. I just want to point out that there's a key tenet of GDPR that hasn't been mentioned is the risk-based approach. I think it's something that has to be taken into consideration because, we can argue all day about, when was the right time to simplify or harmonize, whether it was the fitness check, whether it was the periodic review, but we represent SMEs, marketing service providers. I mean, they are dealing with GDPR, DSA, DMA, Data Governance Act, Data Act, AI Act, the Unfair Commercial Practices Directive, Digital Networks Act, and maybe now Digital Fairness Act. I mean, we have to take an opportunity. If this is the opportunity to simplify the data protection reform in its entirety, or at least...
Sorry, but what is your question?
My question is, for those who oppose the digital omnibus, I mean, we need to simplify where we can. So to those who oppose the omnibus, what is the solution for SMEs to actually comply with all these legislations? And also that applies to consumers who are also just as lost as SMEs.
The question is how to comply with all the legislation.
If for those who oppose the digital omnibus as a way to simplify, what is the way forward?
Okay,
Thank you.
maybe we'll take the other question at the same time. I see Ichaso and someone behind as well.
Yeah, thanks so much, Ichaso Dominguez from EDRI, and thanks so much for the debate. One of the questions that I have, because I hear you on enforcement and fragmentation, I think this has been a concern when it comes to the application of GDPR, e-privacy, and others. But I still don't understand what's the guarantee that the digital omnibus is actually going to address and help with enforcement and less fragmentation? Because what I hear is not lots of legal certainty in any of the provisions that has been addressed, potential years of litigation before the court, because we know that many of the provisions go against primary law and the fundamental right of data protection, and that of privacy as well. So is there actually a guarantee? Do we know for sure that this is going to help with enforcement and fragmentation when it comes to enforcement? Because this is one of the promises, and I'm not sure this is going to be delivered.
What is the guarantee in the omnibus?
Yeah.
Okay, thanks.
Yeah.
Sorry, we have to, I'm trying to, we had someone behind you. Oh, thank you.
It's working? Yes. René Marieux, Open University, Assistant Professor on Data Protection Law. I am wondering if the goal of this omnibus is simplification and clarification. Why the omnibus methodology to get there, which in practice had so much influence and so much ad hoc influence, it seems, of different industry groups, that the total package is a bunch of ideas that don't create any, or that create maybe some coherence on some little spots, but also create a lot of disharmony, where actually the Court of Justice is slowly getting towards harmony, the EDPS, the EDPB are going towards harmony. It seems to me that this is not. So the question is actually twofold. One, why this methodology? And two, why not propose instead to just give a lot more resources to those groups, EDPS and EDPB, for example, that are actually working on creating coherence?
Thank you, thank you. I was just trying to summarize if I understood well. First question, what if you oppose to the omnibus, which seems to be the way to comply with the EU digital rule book? That's what I kind of understood. How do you comply if you oppose the omnibus? Second, where do you see the guarantees in the omnibus that I guess fundamental right would be protected, or that maybe the omnibus promises will be met? And third question, why an omnibus? That's how I understood the question as well. Do you think it's the proper instrument to address those? If I correctly summarize your question. Whoever wants to take the floor, of course.
I'm sorry I can start to reply to the three questions. Indeed, with this omnibus, by the way, we are not touching only on GDPR. We are touching on AI Act, and then Data Act, platform to business regulation, etc. So there are indeed, we try indeed to simplify, consolidate, and so on. So this is indeed an endeavor from our side. On the enforcement, and this was a question from Ichaso, yeah, we think that by harmonizing a number and by providing this clarification in the text, we will foster better, more consistent enforcement. And as the deputy chair of EDPB mentioned, the GDPR procedural rule proposal, which is now has not being adopted, which is going to be implemented. This is another layer. And then, of course, we rely very much on the DPA and the EDPB, EDPS, and this is why this Helsinki statement about the consistency, the support to stakeholder and engaging with stakeholder is really very much welcome. So there are not one short solution, and there are several solutions. And then on the question on the methodology, well, why did we choose to come with these targeted amendments? Precisely because initially there was a discussion, should we reopen, should have a full-fledged reflection on the GDPR? And then there was a unanimous reply, I mean quasi-unanimous, you can always find people, but a very strong reply from civil society, from business, from academics, do not reopen the GDPR. Do not, and we agree on the principle, but there are fixes, technical, boring fixes that we can introduce. And you have fixes here in this article, that one, that one, that one. And they corresponded to all analyses that we have been carrying out during the year. And if you look at what the discussion taking place in the member states, because it's not only the Commission, it's also in the member states, there has been discussion, and you look at the different lists, which, by the way, came after the Commission proposal, but we were reassured to see that they were very much matching what we were thinking and what we had found at European level, which means it's not, a completely crazy idea. So on the methodology, this is a reply. We come to fix things which are problematic, and we are not touching on things which are working well. And on the resource of EDPS, EDPB, giving more resources, this I can say, I'm leaving now. This is indeed a very good idea. We should give more resources to the supervisor. Thank you very much.
Thanks, God. It's a nice last word. It's recorded, so I think we can use it for later. Sophie, you wanted to react as well?
No, in terms of method, I think if there was consensus not to reopen, then we don't reopen, and then we go to the digital fitness check, and we get the evidence so that we can have a discussion that is based on evidence to identify the fragmentation where it is, and then solve it. Because if it's only very tiny tweaks, then maybe that was not that urgent in terms of timeline. Yeah, I guess that's my immediate reaction.
Victoria, you want to?
No, go first.
Okay, I think the urgency, going to challenge you there a bit, Sophie. From the industry perspective, implementing the GDPR is a day-to-day challenge. So very much evidence-based from our perspective. When I ask my European tech companies, what do you think of the GDPR? We are not for reopening. We did not ask the Commission to reopen it because we thought it was actually a risky move. But yes, there could be some tiny effects. And I can tell you that my documents that I've shared with my data protection colleagues from within the company, it was 100 pages long, if not more. So
yeah, no, but I would love to see whether it's
very
related
much
to
needed.
Complexity of the law, whether it's related to something else. I fully acknowledge that compliance is a resourceful exercise. I've seen like 6 figures for recording of processing activities. This is crazy. 7 figures for small policy for a data science environment. This is crazy. So I think the compliance world has
It's bigger than that. If I may maybe provide detail, it's not only the need for enforcement, it's a need for what is really risk-based approach. How can we respect the GDPR first intention? How can better harmonization between the member states? Can we have more clarity on some interpretation, on some definitions? So there are some fixes that were very much needed. Can we kind of discuss the consent fatigue? Because that discussion has been going on in Brussels for years. So I think the GDPR and the little fixes are welcome developments from the industry perspective. That does not mean at all that we want to change the fundamental basis of the GDPR. No, data protection needs to exist, but European tech companies are very much welcoming the possibility to have clarity so that we can innovate more and spend more time on innovation rather than on compliance.
Thank you, Victoria. Augustine, you wanted to react as well.
And especially to your point on the different pieces of EU law. You mentioned, I think, 5, 6. We can mention even 10 EU laws, but I can mention 100 of national laws as well. So the question is, where lies the problem for scalability? And we already talked that earlier today. And when it comes to the digital omnibus, of the omnibuses, because there are many, perhaps there are too many, the question is also about how things are being done. And it's not me only who's saying that. It's not the people that raise the hand saying that this is the regulation. It's also the ombudsman that's saying that, the same thing. It's about if we are in favor of evidence-based policies, why we don't do that? Why we come with a proposal just taken out of the drawer like this from one day to the other? Why we cannot have a proper discussion? And it's true. And we did also not support the opening of the GDPR now, especially because we got also the new rules on better enforcement. But at the same time, I think it's healthy to have this conversation, but not in the current context of the omnibus. it should have been done differently. It should have been done according to the procedural rules that the Commission has adopted for itself, that the Ombudsman is telling to the Commission that you have not even solved them. And what is the response to that? And we're going to change the rules. Sorry, like this, it doesn't work. No, if we are serious about lawmaking at the European level, we need to have an evidential basis for that. And I'm sorry, but here there are far too many questions that have not been addressed through evidence.
Thank you, Augustine. And on that note, I think we reached the end of the panel, but I would just ask you a very last question. If you encountered a genie of data protection in your basement and you have 5 seconds to express a wish to change the GDPR, what would it be? Who wants to take the floor? It's just to have a funny way to wrap up this really interesting discussion. Thank you again. I really think it was amazing. I'm really super happy about the way the discussion went. And I think we need one day to address all the issues that we just opened today. I think we agree on that. So let's leave it full of joy, but maybe with the answer to the
I'll go with 3 concepts or 3 words to be short. 1, clarity and harmonization. 2, risk-based approach enabling innovation. And 3, to conclude, la boucle est bouclée, as we say in French, a digital clearhouse where authorities are working more together and better cooperation. Because empowering the EDPS or the EDPB is a nice thing, but that won't solve the problem. We need better cooperation. So harmonization, risk-based, digital clearhouse.
Thank you. It's 3 wishes, but I guess we can allow that. Olivier.
No, thank you. It's a wish on the process. And again, I would say let's have a dispassionate debate on this omnibus. No grand political statement, looking at the text, fixing it, making it work, and in order to stop any negative narrative against the GDPR and making the GDPR, you know, the evil or the source of all problems, because we have many other problems. And so let's fix it and let's close this chapter on the GDPR being a problem, because it is not. Thank you.
Augustine, very short wish.
Let's get on with the implementation and enforcement. Enforcement.
Sophie?
Enforcement, and I'd like to add one more thing, which an observatory of GDPR related practices. You want to fight against negative feelings against GDPR, but I'm not sure you're going to find a solution in the letter of the law. I think you need to look at the ground and see why compliance is so difficult. This is where I would start.
Okay, thank you, Sophie. I think it's time to wrap up, and thank you so much for the discussion. I think it's time for a coffee break now, right? Thank you again. I think it's not the first and the last time that we will discuss the omnibus. I think we will meet again in the future, maybe not in the same room, maybe with different people, but as you know, the legislative process is ongoing, so we will probably have numerous occasions to discuss this omnibus. And be prepared for the early February plenary of the EDPB, when you will have some nice reading about this omnibus adopted by the EDPB and the EDPS as an opinion. Thank you so much, and see you later forever.